Good morning. Are you Justice Joanna Lewis?
Yes, ma'am.
And this is cause number 24, DCCR 0766. Ms. Lewis was granted probation for aggravated assault with a deadly weapon back in September of 2024. This is a motion to revoke. She pled true to counts 1, 2, 3, and 4. I received an updated pre-sentence report. Have you both had an opportunity to review that report?
We have your stay asked.
And this was unagreed, correct?
Correct. Yes, Your Honor.
All right, Mr. Parker, you may proceed.
Your Honor, just first like to point out she has no new cases. Um, Part of her issue, I mean, she's not reported. She's claimed some mental issues, which although the probation department didn't have knowledge of, I think they've confirmed that by talking to uh, the infirmary, the jail. Um, and I believe she did have issues. She was in a wreck, and I mean, I can tell you, she's acknowledged to me that she's told me the right things, which was promising. That she didn't go to probation because she was in a wreck and she was uncomfortable and it's hard to. She also acknowledges, I should have gone. I should have had better contact with my probation officer and done what I'm supposed to do. She's very convincing to me that if she's given the opportunity, she's taking the medications that she needs to take, and that she will be able to complete her probation. Uh, I, I'm asking the court to put her on the high medium caseload, um, and see if she does what she says she can do. If she's on her medication, and uh, we can see if she actually will report. I mean, it won't take long to see if she reports and she starts doing community service. They're administrative violations pretty much, and I'm asking the court to give her another chance. And do you want to address the court? Hold on. And she likes to address the court, Judge.
Go ahead.
I would like for another chance, and I promise that I'll make sure that I do all my things that I'm supposed to do for my probation.
Explain to her what you told me about why you didn't do what you're supposed to do the first time.
I got in a car accident, but like I said, I'm not using it as an excuse. But I really, I was out on transportation and stuff like that, and I couldn't really make it to where I was supposed to make it, and I've been taking my medicine. I've been doing everything that I'm supposed to, and I promise that I'll continue doing everything that I'm supposed to do to complete my probation.
And you told me what should you have done when you weren't going? You should have done what?
Should have reported.
And you should have communicated
I
with
should
them.
well, I should have communicated, especially with my probation officer.
Mr. Coleman.
I don't have much to offer, Judge. Same things and making representations that they're easy to do and easy to say. But it's the deeds, the actions of the defendant that matter. And Judge, she's essentially done nothing on probation. If it's a mental health issue, she's got to take the first step, Judge. She has failed to enroll in Spindletop to get those mental health, if any, whatever mental health issues, if any, addressed. You can't do this probation for her, Judge. And the definition of insanity is doing the same thing over and over and expecting a different result. Putting her back on probation, given the fact that she's uh, just utterly failed, would be, in my opinion, doing insanity, doing the same thing, expecting a different result. She's just not going to. Her past behavior has indicated she's just not going to be successful at probation.
Your Honor, I don't think that's fair representation, because obviously the probation department didn't know she had a mental health issue. They acknowledged that. And when they do know that, they take steps to help these people that have problems. And she did take steps to get on medication, and she has improved by being on medication. I think with the assistance and the knowledge that the probation department has, that she has a mental health issue and she actually is taking medication for these problems, it may help her, and she may have a better chance.
So, so I'm looking back at the original pre-sentence report from 2024.
Mhm.
And so it was noted in that pre-sentence report in 2024 that she had an appointment with Spindletop for a specific day that she failed to show for during the that time period. So it's not a surprise to anyone that there was some issues back then that weren't followed through with to go to Spindletop. That was ordered it was in the order back then for her to be assessed for services at Spindletop, which never happened. So here's the thing. Here's where I am. I don't disagree that, I mean, Miss Lewis has really no criminal history. This is the only case. There's clearly some mental health issues as well as drug issues. But I'm not going to just say, okay, go out and do Spindletop, because we've already said that a couple of times. So what I am going to do, and this is your opportunity to take advantage of this, Miss Lewis, is I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. I'm going to find those counts true. Going to find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation, but I'm going to order that you enter and successfully complete the special needs safety program. That will address all of these problems. If you say you want and need help, won't matter if you have transportation, you'll be in custody to get the help that you need. Either you take advantage of that or you don't. So you're going to get all the tools for both mental health issues, drug use issues, self-medicating, all of that. And when you get out of SafeP, you'll be on the high medium caseload in order to do whatever it is to follow up with Spindletop, follow up with drug treatment. And at that point, if you don't do it, there's no arguments that your attorney can make that would convince me that you should get another chance. This is your chance. Do you understand?
Yes, miss.
So this was not an agreement. You do have some rights to appeal. I'm handing you that written certification. I hope you take advantage of this and get everything you need because you'll be given that opportunity. Okay.
Yes, ma'am.
All right. Good luck to you.
Thanks, Judge.
Thank you.
You got one more case for coming to beat up for me.
See,
It's a, we're calling it, it's a bond.
it's a bond hearing. Let me see what that one's. I'm just going to number the case. Entree in. I'll number the case.
Do you?
It'll be fine by next week.
He went to the hospital now.
Hmm?
He went to the hospital.
Yeah, it's Tuesday. We're not set till Monday.
You know where to find me.
Okay. Well, then I'm
If
not-
there's some issue that I find out of something that is a major issue where he would not be able to be here for trial, I'll check in before I number the cases.
Saying when they call you.
I'll call them and let them know and talk to them before I number the cases, but I anticipate it will still be numbered.
Thank you, Judge.
All right, Mr. Parker, on Gabriel Cruz. And Megan, I'll get you next. All right, sir, are you Gabriel Cruz?
Ma'am.
And we've got cause numbers 26 DCCR 0373. Mr. Cruz is charged with stalking. Cause number 26 DCCR 0374, charged with violating a protective order. And then cause number 26 DCCR 1060, charged with violating a protective order. And the state has filed a motion asking that I increase the defendant's bond. Hold on, I need to see what the bonds are in each case.
I believe they're
100,000.
In all three cases?
Well, individual, $100,000 in each individual.
300,000 total.
That's what
Yes.
I need to know.
Yeah.
All right. And has not made bond in any of those. Is that
He-
correct? Or he
He
has?
made bond in the first two, and then he picked up the last new case, and he's in jail on that case, on that. He has not bond out on that charge.
And the last offense, it looks like has that same
The-
offense date. It was just indicted on, at least on my docket. Let me look at
Oh,
that.
it's
because-
a different offense state. It's my understanding.
Let me look. Oh, okay. Well, so offense date, it's not, okay. It's not. So the offense date in that last one was March 1st of 2026.
That's right.
So 2 weeks or so after the first alleged offense of violating a protective order. Mr. Coleman, you may proceed.
Yeah, I filed a written motion. I have no doubt the court's reviewed it. I just hit the highlights, if I may, Judge. The criminal history, I just would ask that the court reevaluate the bonds in light of this defendant's criminal history that includes a conspiracy to possess or distribute cocaine out of the federal court, 2010, unlawful carrying a weapon, Jefferson County, 1994, possession of controlled substance, 1998, an adjudication for possession of marijuana, state jail amount of marijuana, 1998, and a arrest for an aggravated assault that was ultimately dismissed. I think it's still probative in this setting, that history. And in addition to the criminal history, Judge, I'd ask that the court consider the fact that this defendant allegedly committed this new offense of violation of protective order while out on bond for violation of protective order, and it involved the same victim, Judge. I think there are a lot of concerning issues here related to public safety and the safety of the victim in this case. I submit to the court that $100,000 bond on each of these cases is insufficient. I'm proposing a bond of $250,000 in this case. I'd ask the court consider this.
I'm printing a couple of PCs as well. Give me just a second. I'm gonna get some stuff printed out so I can take a look at that. The PC in both of the in all of the cases. So
Whatever you do.
y'all stop talking.
Sorry.
Was there one more that printed or now? I guess. Okay, I see. So the one of the stalking and protective orders the same.
Yes, that's right.
Mr. Parker?
Your Honor, I would like to point out that this is he and his wife are going through a divorce, and it's been nasty. Uh, part of part of the communication or contact with her was because she wanted him to see the child and told him to come get the child, and that's why I was there. I think I can't just and give me, Judge. I haven't talked to him after he bonded out. So I don't have a whole lot of information. And I just received a new case. So I'm not familiar with all the facts of the new case. So I'm limited to what I know. But my communication with him is that he's been contacted by her, and I'm sure she was admonished by Judge Freeze or whoever that to not contact him. But he did say that was one of the reasons she has contacted him to see his child, and then she tries to use that against him, and which is common. We see this a lot of times. There's a divorce going on, and they want to use anything they can. But we're asking that. I mean, he's on there's third-degree felonies, and $100,000 is a high bond. He had some help on the first two cases. I'm not sure if he's going to be able to have that help on these cases, but we're asking to leave the bond the same. $100,000 on with other restrictions, I think, is appropriate for these types of cases. If he was out and was intended to hurt her, he could have hurt her. I think even the facts that Mr. Coleman has raised and some of the stuff is that if he was around her, he could have hurt her if he wanted to, but I think it aligns with what he was telling us, that he was, even though he shouldn't have gone over there to see his child, that's more than likely what happened. So we're asking to keep the bond the same, Judge, with other monetary restrictions.
Right. So Mr. Cruz, if you have a protective order against you, I know what those say, and I know what the judges and the magistrates tell you about that. No one can give you permission to violate that protective order. And if you guys were just talking about a visitation of your child, I wouldn't have a probable cause that has an allegation that there was 96 text messages, 47 emails, 9 voicemails left stating that you don't care what the protective order says and that you're going to do what you want to do. In addition to pulling in the driveway, that's on February 23rd. 2 weeks later, same thing, numerous calls, and the officers locate you in your vehicle a block away from the house driving past. So it obviously, regardless of whether you have already done anything to hurt her, my job is to make sure that that doesn't happen. And I feel like you have completely disregarded the protective order that was placed on you and the rules that were placed on you down in another court. And so at this time, I'm going to grant the state's motion. I'm going to raise the bond in cause number 26 DCCR 1060, which is the last offense date of March 1st of 2026. I'm going to raise that bond to $250,000. Condition of that bond, if you make it, is that you wear a GPS monitoring device at all times and that you would be on house arrest as well. So you would not be allowed to leave your house. I am going to modify the conditions of your bond in the 2 other cases that you've already made bonds on. Additional bond conditions in those 2 cases, which is 26 DCCR 0373 and 0374, are that you have a GPS monitoring device on at all times and that you are on house arrest. You're not allowed to leave your house without my permission. All right, you can go back with the bailiff. We'll set your case for an announcement.
The bond amount stayed the same in that one?
Yes, I didn't
Okay.
change those bonds amount. I raised the last one
Okay.
and made those modifications.
Okay. I understand. Okay.
This courtroom session featured 2 important hearings that showed how judges balance second chances with protecting public safety. The first case involved Joanna Lewis, who was on probation after pleading guilty to aggravated assault with a deadly weapon. She admitted violating multiple conditions of her probation, including failing to report and failing to comply with court-ordered requirements. Her attorney argued that these were administrative violations rather than new crimes, and explained that Lewis had struggled with mental health issues, transportation problems after a car accident, and had recently started taking medication that was improving her condition. Lewis personally apologized to the court, admitted she should have stayed in contact with her probation officer, and promised to do better if given another opportunity. Prosecutors, however, argued that she had repeatedly failed to follow through with treatment and had done virtually nothing while on probation. After reviewing her history, the judge acknowledged that Lewis had no significant criminal record beyond this case and recognized that untreated mental health and substance abuse issues appeared to be major factors. Instead of sending her directly to prison, the judge revoked her probation, but immediately continued her on supervision under a new plan. Lewis was ordered to complete a specialized treatment program designed to address both her mental health and substance abuse issues before returning to intensive probation supervision. The judge made it clear this would be her final opportunity, warning that any future violations would likely result in prison. The second hearing involved Gabriel Cruz, who faced stalking and multiple charges of violating a protective order. Prosecutors asked the court to increase his bond, arguing that Cruz allegedly committed another protective order violation while already out on bond for similar charges. They also pointed to his prior criminal history and claimed his repeated conduct posed an ongoing risk to the protected victim. The defense argued that the allegations stemmed from a difficult divorce and child visitation disputes, claiming the protected person had contacted Cruz as well. But the judge focused on the evidence presented, including allegations of dozens of text messages, emails, voicemails, and repeated visits near the victim's home, despite the protective order. Concluding that Cruz had repeatedly ignored court orders, the judge increased the bond on the newest case from $100,000 to $250,000. In addition, the court ordered GPS monitoring and strict house arrest on all 3 pending cases, emphasizing that protecting the alleged victim remained the court's highest priority while the cases move forward.